We're joined by Professor Andrew Horwitz from the Roger Williams University School of Law. Professor, thank you very much for your time.
My pleasure to be here.
So, look, if former President Donald Trump is indicted, I suppose it's possible that prosecutors would allow him to turn himself in rather than them going out and arresting him. But what happens after that, Professor? What is life like for someone after they have been indicted?
Well, the first step is the actual processing. So he would need to be fingerprinted. He would need to be photographed. I've heard some discussion already in the media about whether or not he would be handcuffed. That's really entirely up to the arresting authorities, whether they feel like that's necessary or not. And I think the argument's cut in both directions. On the one hand, you want to take the position that everybody should be treated the same because nobody is above the law. On the other hand, is there really a necessity to handcuff him? Certainly, you wouldn't think for security reasons there would be. Then there's, the process of getting his personal information and creating the documentation. He then would be brought before a judge or a magistrate where he would be arraigned. And there would be a discussion about whether any bail needed to be set to assure his appearance in court.
When we talk about someone being indicted, that is when evidence is brought by a prosecutor to a grand jury, and the threshold to issue an indictment is probable cause. People have heard that phrase a lot. How would you define probable cause to a layman?
Well, that's a great mystery to many of us who practice law. There really isn't a good concrete definition of probable cause. You often hear people using the language of sufficient level of evidence to make it more probable than not that a crime occurred and that the particular individual who is suspected is a person or the person who committed the crime. And that's, I think, a reasonable working definition of probable cause.
Of course, to secure a conviction, the threshold for that is beyond a reasonable doubt, which is a much higher threshold than probable cause. I wonder if you think the prosecutors in this case, when they're looking at who the potential defendant is here, a former president of the United States, do you think that they're looking to indict him not on the threshold of probable cause, but on the higher threshold of beyond a reasonable doubt?
I'm sure that that's the case in this particular scenario, but I think that it's the case in many scenarios as well. A prosecutor is ethically bound not to move forward on charges unless they are fairly convinced that they can prove a charge beyond a reasonable doubt. So in the normal course of business, you would not have a prosecutor try to secure an indictment or support an arrest based on probable cause if they really didn't think that they could ever prove the charge beyond a reasonable doubt. But that being said, in this particular case, I can't imagine a prosecutor's office wanting to move forward on the indictment at the indictment stage if they are not really persuaded that they have enough evidence to convince a jury beyond a reasonable doubt.
Well, you and I both know that supporters of the former president are framing this as a political move by the district attorney down there. The DA does have discretion to pursue cases or not pursue cases. What do you think goes into a decision as big as this one for the prosecutor?
It's certainly the case that a prosecutor has an enormous amount of discretion that includes not bringing charges when they think charges are justified. The political ramifications here are obvious and are real, which is why I do think that they would not move forward unless they were really persuaded that they had this case really tightly nailed up and were convinced that they could get a jury to convict beyond a reasonable doubt. Here, I think there are challenging considerations of whether somebody should be excused from prosecution because of who they are, and the specter of whether or not an individual based on power or prestige is somehow above the law. And I assume that the prosecutor's judgment is that there's an important issue there to establish that if there's criminality and it can be proved, charges should be filed, no matter who the defendant is.
Well, no one is above the law, but from what we can understand, and again, you and I are going off what we're reading in the newspapers and seeing on television, so there's a lot we don't know, but it appears the district attorney who prosecutes under state laws is linking the case to a federal election violation. And that seems to be, from what we know, a pretty novel approach in a criminal case. Do you think it's wise to test a novel legal theory against a former president?
That's a very interesting question. I guess it would. The good law professor answer always is it depends. I think it depends on how much of a stretch the prosecutor perceives the legal interpretation to be. And I can't say that I know an awful lot about the particularities of this situation, but I have to assume that they don't think they're engaging in much of a stretch, because I don't think they would do it if they thought they were.
If this thing, if he is indicted, if it goes to a trial, how difficult would it be in, picking a jury for a case like this? Almost everyone on the planet will know the ins and outs of the case before, voir dire.
Well, I don't know that they'd know the ins and outs of the case, but I agree with the premise of your question, which is everybody will have an opinion on Donald Trump. And if you actually could find somebody who didn't have an opinion on Donald Trump, you would wonder where that person has been living and whether they are sufficiently integrated into society and sufficiently attentive to be the kind of juror you would want. So I do think it will be very, very difficult to pick a jury. That will take quite a long time if this case were ever tried before a jury.
There's a lot of legal chess that happens before a trial, and I'm wondering, Professor, if you were Donald Trump's defense attorneys, part of his team, what kind of moves would you be looking at making after he is indicted and before trial?
Well, given the timing and the upcoming election, I think my primary objective likely would be, if I were his lawyer, to stall, so that ideally nothing of significance happens post-indictment in the case before the election. Beyond that, the role of defense counsel once a charge has been filed is to engage in what we call the discovery process, which involves getting all of the information from the government that the government has so that you can prepare to fight against it, but also engaging in your own investigation and your own effort to find and secure witnesses. So certainly I assume that's what defense counsel would be doing.
And you bring up an interesting point in the first half of your answer. Let's be clear here. Nothing prevents someone from running for public office in the Constitution or in law if they have been indicted, correct?
That's correct, because an indictment, we stand on the principle in this country of a presumption of innocence, and an indictment is merely an allegation, and it has not been sort of substantiated beyond the level of probable cause. So we don't treat that as a particularly meaningful event, at least in terms of our electoral politics.
Final question for you, going back to the issue of preserving the jury pool, as difficult as that may be, sometimes judges will take the step of issuing a gag order, which prevents the parties on either side from speaking publicly about the case. Could you see the judge doing that in this case, and should he or she consider doing that in a case as high profile as this?
It should absolutely be considered, and I would say it's probably likely in a case like this. That's going to present some challenges for Mr. Trump as he campaigns, because of course he will want to be speaking about the charge and presumably wanting to speak in his own defense. But it does seem like in a case like this, it would be a wise thing for a judge to do to try to minimize the pollution that's going to be entered into the jury pool in advance of a trial.
Professor Andrew Horwitz, thank you very much for your time.
My pleasure. Thanks.